So I say make I give you a complete update on what happened, what transpired during the Mazi Nnamdi Kanu's trial in Abuja. No be small thing. Now it happened inside that very matter. So they say that Mazi Nnamdi Kanu won the case on that very day. That very day favored him. That was on the 29th day of May 2025. Now I'm going to tell you what happened. They said that the court rejected the federal government's evidence against Mazi Nnamdi Kanu. I was like, wow, what happened? They said because the lawyers to Mazi Nnamdi Kanu were not there during the interview. Now, remember that Mazi Nnamdi Kanu previously said that the interview conducted by the DSS during the interrogation was done under duress. In fact, that they were pressing his neck. Now I can say, hey, make I talk him. If you not talk him, go beat you. If you not talk him, we go use 2x2. If you not talk him, go use 4x6. If you not talk him, you go hear way. You go not talk him, you go hear Pepe. Oh, yeah, talk wait till we talk. Now waiting Mazi Nnamdi Kanu come and come talk inside the court to say, those things when I talk, now when they press my neck, now I make I talk him like that. So after the judge don't look the matter, look and look and look and I say no. On a normal, these lawyers who are supposed to be there when you are interrogating this man. Why did you do it alone without bringing his lawyers? If his lawyers were there, he won't say it's under duress because the lawyers would have been the witness. You dey see am because I go phone you for now wake. You get to the point now. Now waiting happen. Court reject federal government evidence against Nnamdi Kanu. Now, let me tell you something. It is possible that the interview was not conducted under duress. Get the point too. It is possible that the DSS did not run the interview with Mazi Nnamdi Kanu under duress. But because the lawyers of Mazi Nnamdi Kanu were not present, it is null and void. It doesn't matter whether they did it well or they did it wrong. Once Mazi Nnamdi Kanu say, no, that interview, I don't want it again. That interview is not valid. The lawyers, the judge will agree. Which means that there is still, an atom of law working in the country. Because if the law wasn't working, nobody will favor Mazi Nnamdi Kanu. You get to the point. Nobody will favor him. They will say, like, we no agree on your own. We must carry on. But because Mazi Nnamdi Kanu rejected that interview, the judge now said, yes, because you went through the back door to do that interview, we no still agree. We now agree with Mazi. You dey see him. So, law court and all that is all about vice versa. It may favor you today and it may not favor another person. So why am I saying that is because when these things maybe favor Mazi Nnamdi Kanu, people go say, hey, why now they don't do Ojoro. So if to say this government no Ojoro only, now they do, they for no favor Mazi Nnamdi Kanu. So they say this judgment na vice versa. Any evidence we no get any basis, they will throw it out through the window. So now so the judge they fling the thing for outside the court, this thing, the thing can't land outside scatter. So they see the way they bring evidence against Martin. They see the matter. So now the Abuja division of the Federal High Court on Thursday rejected the evidence sought to be tendered by the federal government in the ongoing trial of Nnamdi Kanu, leader of the Indigenous People of Biafra, IPOB. Justice James Omotosho, in a ruling, agreed with the argument of the defense counsel, Paul Erokoro-San, that the Supreme Court had ruled that in extracting an extrajudicial statement from a suspect, the presence of his lawyer is mandatory. You see, they said that the Supreme Court said that any any interview, any statement you want to get from a suspect, that it is a must, it is mandatory, it is obligated, it is obligatory, it is obligato that the lawyer of that very suspect must be there for that statement to be valid. So, for that statement to be valid, the lawyer must be there. If the lawyer is not there, that statement is null and void. Mr. Omotosho held that through a provision of the Administration of Criminal Justice Act, ACJ 2015, used the word may to mean that the presence of a lawyer to a suspect is not a must while making a statement. He could not close his eyes to the apex court decision. So they say that an act, a law that ruled in 2015 said that may, which means the lawyer fee day there, the lawyer no fee day, it doesn't matter. But when the Supreme Court came and said it is a must to, now the man self can't shock. He said, man, we leave this thing. They say, lie. The Supreme Court's ruling is the final because the Supreme Court now be the organ pata of all the courts in Nigeria. Now, the judge stood down the matter to deliver a ruling on the admissibility of the evidence sought to be tendered by the federal government. The development occurred after federal government counsel, he said now Suraj Saida, who is also a senior advocate of Nigeria, and Mr. Kanu's lawyer, Paul Erokuru, who is also a senior advocate of Nigeria, adopted their written addresses and argued their case for and against the propriety of the evidence. Ruling after the trial within trial, Mr. Omotosho held that the issue is whether, with regard to the evidence placed before the court, the statement of Mr. Kanu were admissible in law. He stated that the burden of proof in a trial within trial lies within the prosecution to prove his case. So, this matter now, not only that one we didn't take interview Mazi Nnamdi Kanu, 9 days step down, 9 day the court reject. The other ones are still there. The evidence where they don't hold against Mazi Nnamdi, they never still cancel those ones. I mean that one where they bring on the 29th. That was the one that the court, kabuled. You understand? That was the one the court kabuled. You understand? Kabuled. Yeah, okay. Now, the judge said in the mind of the court, the defendant did not establish the allegations of involuntariness in any way. So they said that Mazi Nnamdi Kanu did not show any act of, say, he no one do the, the interview, the statement. He don't want to write statement, he don't want to do the interview and all that. But based on that very ruling, that ruling is strong. You understand? They will be going against the court if they don't, do the needful. He said the video recording showed that Mr. Kanu was relaxed when he was interviewed by the State Security Services, SSS operatives. He said the video and statement showed they were the same. He said they know who Mazi Nnamdi Kanu for NECO. However, the judge said the court must not close its eyes to the fact that Mr. Kanu repeatedly said in the video that his statements were taken without his lawyers. You see? So he held that relevant laws state that under Section 17(2) of the ACJ, the statement of a defendant may be taken in the presence of a legal practitioner of his choice or where he has no counsel. An official of the legal aid counsel shall be present. Mr. Omotosho, however, added that the Supreme Court had ruled several times that the presence of a lawyer for a defendant when he is making his confessional statement is mandatory and the security agencies must comply with it. He said the charge against Mr. Kanu was a grievous one, requiring the presence of a suspect lawyer during the recording of the statement. He said the case of Mazi Nnamdi Kanu say is strong like stone. Say no, the allegation when federal government put on top the basin when Mazi Nnamdi Kanu hold on top in head, say he heavy. So this kind of case is not something you treat with a kid's glove. It is something that requires attention. So the DSS failed in establishing, this law, in making this law relevant, which means that they did not respect the Supreme Court. So this court now backed the Supreme Court and said, because you did not respect the Supreme Court, oh yeah, throw this thing out. The statements are inadmissible in light of this omission by the prosecution, Mr. Omotosho said. He held that the 2015 statement obtained from Mr. Kanu are inadmissible in law due to the absence of his lawyers. Because on no carry lawyer interview him, throw this thing through the window. That's what happened. The judge subsequently expunged the video evidence and statement obtained from Mr. Kanu on these grounds. The objection of the defendant's counsel is upheld. The statement of October 23rd, 2015 and November 2015 earlier admitted in evidence are rejected, the judge said. Mr. Omotosho proceeded to mark the statement rejected and also expunged from the court's record the video recordings of the interview and statement writing session that Mr. Kanu had with the SSS officials in October 2015. So we are still dealing with October. They never even come to 2020, 2021 and all the rest of it. Now, wow, this matter is strong. The video recordings were earlier admitted in evidence by the court during Wednesday's proceedings and marked as Exhibit PWQ and TPWR. Mr. Omotosho on Wednesday ordered a trial within trial following Mr. Kanu's rejection of the extrajudicial statement sought to be tendered by the prosecution. The IPOB leader held that he made the statement under duress. Mr. Kanu alleged that the SSF officials who interrogated him denied him access to his lawyer, threatened not to allow him on bail, and denied him the 1 hour granted to him daily to receive fresh air, given his health challenge. He said he was threatened by the SSS investigator, whom he described as Mr. Brown Ukuaba, an assistant director of investigation. Mr. Kanu also alleged that his interrogators asked him to say things about former President Jonathan and former Governor Rochas Okorocha of Imo. He said he was kept in an underground cell and the video recordings played in court were edited. The federal government witness and SSS operative, however, insisted that Mr. Kanu was never subjected to coercion and that all the complaints he raised were addressed. He denied that Mr. Kanu was subjected to any form of duress or coercion and faulted his lawyer's claim that he was kept in solitary confinement in an underground cell and that he suffered from any ill treatment. The SSS operative said Mr. Kanu was given preferential treatment and served bottled water during the interview sessions. He also denied that anyone asked Mr. Kanu to say things about Messrs. Jonathan and Okorocha, adding that IPOB leaders spoke voluntarily and truthfully in the interviews. Mr. Omotosho then ordered the conduct of a trial within trial to ascertain the voluntariness of otherwise Mr. Kanu's statement. And so the matter take go. Let's listen to our lawyer.
And the Kanu don't win. And we say trial court say you cannot try person where extradite, where go through legal process to bring back to Nigeria. Where you go by night, still I'm like thief, come back, then you go say you go try am. Say that kind of thing no day possible under Nigerian law and under international law. And so I dey talk am since last year, July. So today I dey happy say Court of Appeal don't validate them.
So what will be the next step for now? The judgment now, it means say Nnamdi Kanu go come up for DSS detention.
So the judgment now, the process we say we'll go get the certified copy of the judgment, we go serve the DSS, and then from there I ain't go home. Because the Discharged Aqitted means say he no get case to answer again. So there won't be any trial. Remember last July, I granted an interview to BBC where I said that there is going to be trial within trial and that Nnamdi Kanu will not undergo any trial. I made that prediction far back as July 2021, and today I am vindicated.
What if government now won't go higher court?
Well, if they go want now, maybe now they are right. If they want go higher court, maybe Supreme Court. But we say the moment we go higher court, the thing where the lower court don't nullify. They're like that.
Is there one thing record to add?
Well, you do well as a follow stop. I'm done.
Okay.
All right, my people, make on a drop on a statement there. Make I see what you on the reason. I will come back with more updates. Please use tap send to send money to Nigeria. God bless you and share this video. You don't win, be that too. Hallelujah.